Lil Durk, breaking news, trial coming up in weeks. This is where everything starts to get heavy. We talking about what the government wants in, what the defense doesn't want in. We break this all down right now. Let's go. Hit that like button like y'all like something. Comment y'all thoughts as they pop out, because I might be able, you know what? Let's go. Bilal Esley, first assistant United States. We already seen all that crap. Attorney for plaintiff, United States District Court for the Central District of California. United States of America is the plaintiff, and Durk Banks, obviously, and all his homeboys. What it says is this: government's notice of lodging under seal exhibits and supplemental memorandum in opposition to defendant Banks' motion in limine to exclude Rule 404B evidence. Plaintiff United States of America hereby files its notice of lodging under seal exhibits and supplemental memorandum in opposition to defendant Durk Banks' motion in limine to exclude the government's proposed Rule 404B evidence. So basically what we just read is the government basically saying they're not letting the defense block this evidence quietly before trial. Durk's lawyers tried to keep certain material away from the jury, and the government responded by saying this evidence matters because it goes to intent, motive, and a pattern of behavior, not just character attacks. The fact that the exhibits are filed under seal tells you this isn't random at all, nor is it speculative. It's sensitive information, and the courts actually believe this could seriously impact how a jury understands the case. Just gonna be honest with y'all. In plain terms, the defense tried to close the door early, and the government is like, nah, we're not doing that. We're not doing that, Judge. Judge, let all this shit in, bro. Judge, let them see all this stuff, bro. This helps us paint the whole entire picture. And they believe it connects the dots and strengthens their overall theory of what exactly actually happened. But also, bam, y'all know what to do, man. Scan that thing right there with that QR code, or tap the link in the description. And that way, you're going to have you all the way hooked up. That's free cash, free cash. Hit right there for free cash, or hit the QR code. And next thing you know, when you use some cash, order you some DoorDash. Don't cash app nothing to Setting Nash. I'm not asking for it, but win some money, win some money. But let's continue on with this thing. Roll it. This filing is based upon the attached memorandum of points and authorities, the attached exhibits A through B under seal, the files and records in this case, and such further evidence and argument as the court may permit. Dated January 2nd, 2026. Bilal Esley, because we ain't calling you Bill, Alexander B. Schwab, Ian Yanello. Yeah. Anyways, let's get down to it. Memorandum of points and authorities. This should be good. The government files this supplemental memorandum to provide the court with additional information related to motions the court will hear on January 7, 2026. Namely, defendant Banks' motion in limine to exclude evidence defendant claims is Rule 404B evidence, docket number 258, and defendant Wilson's related motion to sever the trial should the court admit the disputed evidence, docket number 242. The related motions were filed on October 6, 2025, and the government filed its omnibus opposition on October 27, 2025. During the November 18, 2025 hearing, the court heard argument and ruled on the matters, but deferred argument on the related motions to January 7. Consistent with the parties' stipulated trial schedule, the government provided an amended Rule 404B disclosure on November 17, 2025. As set forth in the government's opposition, the related motions are basically on an early preliminary disclosure of certain evidence the government intended to introduce at trial. See docket number 274 at 6 through 7 in 2. Footnote 2 of the government's opposition explained that the disclosure would be supplemented in November 2025, consistent with the parties' agreed upon trial schedule. On November 17, 2025, the government provided the defendants with a revised notice, which the government currently lodges under seal to supplement the record before the court. See government's November 17, 2025 notice, XB, Redline government's November 17, 2025 notice, reflecting updates from the September preliminary disclosure. Among other things, the revised notice makes clear that the evidence described in Section 1, evidence related to OTF's and Durk's Banks' rivalry with TB, aka Quando Rondo, and Section 2, evidence establishing a relationship between co-conspirators and defendants' admissions related to the scheme, is direct evidence of and inextricably intertwined with the charges in the second superseding indictment, and in its introduction allows the government to present a complete story to the jury. What we just read is the government basically saying this isn't new or random evidence. They're trying to sneak in at the last minute. They're telling the judge they already disclosed this Rule 403 material to the defense on schedule, updated it in November, and now are formally lodging it with the court under seal, because they just trying to say, it's actually sensitive as hell. So when they talk about Rule 404B, I don't know what that is. That's evidence of prior acts or conduct that prosecutors are allowed to use, not to say someone's a bad person, but to explain intent, motive, relationships, and key patterns. And here's the key part. The government is arguing. Yeah, they saying that this evidence is directly intertwined with the charged conspiracy. Meaning, in other words, it actually helps the jury understand how the alleged co-conspirators are basically connected and all that BS, like the fight and all that shit with Von and goddamn Quando Rondo, and what events happened, what events actually didn't happen. And that's why they're saying it allows them to tell the complete story, which shit, this could even be lyrics and all this shit too, man. It's a whole lot. So they'll say some, but they're not going to give everything. It just is what it is. But in plain English, the defense is saying this is unfair past acts evidence, and the government is responding saying, no, this is essential context. So Drew and them saying this ain't got shit to do with it. Fed said, no, he keep on doing shit like this. It finally caught up to his ass. You see what I'm saying? So it just basically helps explain the relationships, rivalry, and how the alleged scheme actually worked. And we will see exactly what it sounds like even more. Roll it. And this is where Drew got to do what he do right here. Defense counsel's arguments during the November 18th hearing crystallizes the necessity of the disputed evidence. During oral argument on November 18th, counsel for defendant Banks underscored why the government's proposed evidence is necessary to prove its case and rebut defendant's core arguments at trial, including 1, that OTF is not a criminal enterprise. That was November 18, 2025, reporter's transcript at 66, and 2, that the government's case is built on untrustworthy cooperating witnesses. Oh, shit. Indeed, defense counsel rebuked one central witness as a documented liar, a manipulator, and a fraud of the highest order. Bro, whoever that is, it's got to be one or two people. You already know who it is. I ain't saying their name on here. It's got to be one of those two people. The government disagrees. And while defendants are free to make these arguments to the jury, they cannot be permitted to do so in a vacuum. As outlined in the government's opposition, the defendants cannot credibly dispute that TB and his entourage were stalked for hours across Los Angeles and that SR was brazenly murdered by 3 of the stalkers. The disputed facts and the crux of the trial will be who ordered and participated in the calculated murder and why. Yeah, because they're going to have to, they really want to put that why in there anyways. The government's opposition explained that introducing evidence to establish the structure of OTF is necessary to show the relationship among the co-conspirators and defendant Banks' leadership, not just over OTF's legitimate music enterprise, but critically his knowledge of and involvement in OTF's violence. Consistent with gang murder prosecutors across the country, the evidence to prove these facts will include the testimony of cooperating witnesses, the government's proposed evidence, including defendant Banks' text messages with OTF co-conspirators threatening rivals and recruiting co-conspirators to carry out those threats. It's critical to the government proving its case and to rebut defendants' claims, including that OTF was merely and solely a benevolent music enterprise. The government's proposed evidence also provides critical corroboration of its multiple cooperating witnesses who are anticipated to testify that defendant Banks ordered the violence in Los Angeles, used intermediaries, including defendant Wilson, to recruit others to carry out the scheme and promise a reward for carrying out the murder. Preventing these cooperating witnesses from testifying about OTF's connection to criminality would deprive the jury of information, I'm about to say inflammatory, of information necessary to resolve the disputed facts in this case. Accordingly, the government's proposed evidence provides essential material context to show the co-conspirators' criminal relationship and corroborate the anticipated testimony that the conspirators acted at defendant Banks and his trusted intermediary's direction, the Ninth Circuit binding decision. It says right here, from the onset of this case, the government has never alleged that OTF is a purely criminal enterprise. Rather, the government's position is that a subject of members, including defendants charged in this case, operated consistent with a street gang. See example A at 4. As the discovery shows, during the relevant time, OTF operated both as a legitimate music enterprise with a group of members, including defendant Banks, Wilson, and Houston, who operated consistent with a street gang seeking revenge and perpetuating violence on behalf of OTF. The government basically laying out their whole theory on the table. They're saying nobody can seriously dispute that the alleged victim was followed for hours across LA because, it just would be difficult. So the hours part doesn't really make sense. So around LA and then got murdered. No. That's not really what they're fighting for. The real fight at the trial is going to be who ordered it, who participated, and why. And this is where the government says that disputed evidence becomes super necessary, meaning all the old shit that he did, bruh, we got to bring that in because they're arguing you can't understand that answer without showing the whole entire structure. It's like, hey, bruh, they was out there fighting. What was they fighting for? Well, they was fighting because they're part of a gang. Well, they want to bring in how the gang started, how everything is basically going. So it shows the whole structure of OTF, the relationships between the alleged co-conspirators and Durk, and his whole entire leadership role, not just with the music, but in violence. They're saying this is why 404B evidence needs to effing come in. And it makes a ton of sense if we're being honest. I'm not pro Lil Durk. I'm anti-government as hell. But even I got to admit, like, shit, that's what they're going to be going because it's not being used to actually say he's a bad person. It's just being used to explain the knowledge, the intent, the relationships, and show how the alleged scheme actually functions. The government goes further and says this shit is going to include snitches. I got 2 people that come off to the top of my dome. FBI Butters, for sure, to me, is definitely on that, especially watching his charges and his date get moved all the way down. So they're going to say there's going to be texts that come in, threatening rivals, recruiting people to carry out violence, and testimony that Durk allegedly used intermediaries and promised rewards. Their argument is simple. That shit heavy as hell. Because if the jury doesn't hear this context, then the jury actually can't fairly decide the most important question. And y'all know what that question is, right? Who ordered the violence? Who directed the violence? How the hell it was carried out? The jury has to see this according to the feds. So basically, they're saying you're going to kill the whole entire case if you don't allow this shit in. We have to show them and we have to build the whole entire story so that the jury actually is not blind. And that's what they have to prove. So far, shit. But let's keep going. United States versus Smith is material to the highly probative nature of such relationship-based evidence. In that drug conspiracy case, the district court admitted evidence that the defendant participated in a drug operation and purchased several kilos of drugs from a leader of an organization over 10 years prior to the charged acts. The Ninth Circuit affirmed the admission of the evidence, reasoning that evidence of prior criminal acts may be relevant in conspiracy cases to show the background and development of the conspiracy, and that the defendant's prior criminal endeavors with the leader would help the government provide the background and development of the conspiracy and would help explain why the leader trusted the defendant enough to include him in the risky scheme. So too here. Contrary to counsel's claims, the evidence shows that defendant Banks and his close OTF associates, including the defendants in this case, had rivalries, including with TB, discussed violence against rivals, and took violent street action to settle scores with their rivals, including Los Angeles murder defendants are alleged to have committed in this case. And then it goes on to say the government's opposition included typographical error in the citation on page 22, the statement that courts would routinely admit evidence in conspiracy cases where acts would help explain why a co-conspirator trusted another co-conspirator. or another conspirator enough to include him in the risky scheme is quoted from Smith. Admissions contained in certain of the co-conspirator rap. Because I knew it. This shit was about lyrics, bruh. Exactly. So, admissions contained in certain of the co-conspirators' rap lyrics, including those made by defendant Banks and Wilson, also show the structure of OTF in the relationship of the co-conspirators, referencing limited excerpts of lyrics by defendant Wilson and Banks about seeking revenge. Defendants are free to argue that OTF was all about music, but the jury cannot be called on to resolve that issue in an alternate reality of limited and misleading facts. The court should deny the related motions and permit the government to introduce the disputed evidence at trial. And then y'all can see right here, all this shit is under seal and it's under seal. Basically, to end it out, what they're saying is this isn't some made-up theory that they just came up with at all. They're leaning on federal case law to justify exactly why this evidence should actually come in. They're pointing out to prior conspiracy cases where courts allowed evidence of the past relationships in prior acts because it helped the jury understand how the conspiracy actually formed, why certain people were trusted, and how things escalated. Then bring it back to the case and they say, same thing here. You did this right here. You did that right there. I got proof you did that. And also there's other people who acted just like you. And they're doing the same thing here. They're arguing that Lil Durk and his close OTF associates allegedly had known rivalries, discussed violence, and took real world action into settling scores, including the damn murder of the center of this damn case when they mistakenly shot Lil Pop and killed mistakenly killed Lil Pop for Quando Rondo. Pardon me. I know. Y'all like, damn, Dash. But the government's position is that the background explains why people trusted each other enough to carry out something so serious. Like, hey, Johnny over there, he ain't never told. Kelly over there, she ain't never told. Bring them in. We gonna make all this money and kill a whole lot of people. And that's what makes this quote unquote so damn serious and why the alleged conspiracy makes sense instead of this shit actually looking random. So they basically make it clear the defense is free to argue that OTF is just about music, but the jury can't decide the question if they're only shown this basically weak ass version, this sanitized version of the facts. That's why they end by asking the judge to deny defense's motions and allow evidence in, because without it, the jury would actually be forced to judge the case without shit, except for, oh, they did this, they did that, they did this, they did that. And so the government is basically saying, don't even accept the shit that they doing. Accept us, accept us, accept us. And I know it's going to end up having music and shit in there, man. So it is what it is, man. So if they don't do it, meaning the judge don't do it, they're going to still argue that, oh, we need full context and all of this shit. And so that's why making this shit Rule 404B makes it so damn dangerous, because the prosecutors have it to basically say, oh, we're not trying to assassinate your character. We're not trying to say that he's a bad person. We're just saying this is how his ass operates. So I'm not saying he's bad. And yes, the hell you are. If I can hire somebody to murder somebody, that makes me a damn person, a bad person. So it is what it is. They're just basically saying, oh, the government's trying to blur the lines between music, associations, criminal conduct that's allowing evidence and invites the jury to assume guilt based on past allegations instead of hard proof, with the actual evidence in the music is going to 100% paint him out to be a goddamn killer. Durk said he know a person who can do this. He know a person who can do that. He know this and he know that. And all of these goddamn people. And I'm looking like, man, Durk, you know anybody who can shine shoes? Anybody who can scan for me real quick? So with that perspective from the defense, meaning Drew and them, the argument is that the government should have to prove who ordered what, when, and how without leaning on old rivalries and lyrics or these quote unquote alleged goddamn associations that could unfairly prejudice the jury and distract from whether the prosecution can actually prove its case beyond a reasonable doubt. The feds ain't fighting like that though. They dirty as hell. Just gonna be Fair, square, obvious, and honest. The feds don't give a shit about none of that. The feds gonna muddy it up, dirty it up, and fight dirty. So the real fight here isn't whether something bad happened. It's whether the jury decides this case on concrete proof or on the context of the government and what they say, which explains everything, and whichever the judge rules on in this case. So this evidence is basically really gonna shape every single damn thing, everything. And I'm more curious as to how many lyrics they're going to use, because I have an idea of who the two people are. I won't say one person that one there because they love if they ever hear my name again. Only way I answer the little sucker ass buster is if somebody asks me in interviews. Other than that, Judge, F them. DA, F them. But what do y'all think? Do y'all think the government should basically be allowed everything? Because it sounds like to me, they're trying to allow every damn thing that they say is actually important. When Drew is saying, hell nah, hell nah, hell nah. But my thing with this for Drew is, bruh, you should fight to get everything thrown out. As far as whatever the hell. Make all these goddamn motions to dismiss. If you got 100 pieces of evidence, in my opinion, Drew, you should be fighting and filing individual motions to goddamn get rid of all of them, because it's not like the judge is going to say all 100 pieces of the evidence is going to come in. I don't see that shit happening. It's like, oh, okay, damn. They might, psychologically go, well, this evidence right here is not that, that's just my opinion based off of human nature. But I could be wrong. But what do y'all think? Y'all think Durk is cooked if all this alleged evidence comes in, or it really just ain't gonna matter and Drew has to fight for this shit anyways? Let me know your thoughts on this one, man. But click right here, man, to see how Z the Wizard, man, unfortunately ended his New Year's Day in a damn hospital with a bullet inside of his head. Click right here, click right here, click right here, or click right here for the playlist, and I'll catch you on the next one. And y'all know when them Lil Durk files drop, I'm gonna be the best one to cover this shit. So subscribe and hit that like button. Like I said, we might actually go out there and go to the actual trial. But y'all, let me know your thoughts on this one.